Good morning, everyone. Welcome to Assembly Judiciary. Just a few reminders, asking everyone to turn down the volume on their electric devices. We will have public comment at the end of today's agenda so that everyone will have up to 2 minutes to speak on anything under the purview of this committee. Would like to welcome those here in Carson City as well as those in Las Vegas and anyone watching online. With that, Secretary, please take the roll.
Assemblywoman Bilbray Axelrod. Assemblywoman Cohen.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Gallant.
Here.
Assemblyman Gray.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman LaRue Hatch.
Here.
Assemblywoman Marzola.
Here.
Assemblywoman Mosca.
Here.
Assemblywoman Newby. Assemblyman Ortlicker.
Here.
Assemblywoman Summers Armstrong.
Present.
Assemblyman Urick. Chair Miller.
Here. And please mark Assemblywoman Bilbray Axelrod present when she arrives. We do have a few changes. Well, these changes were already made to our agenda. So originally there was 2 bills. We are now having 1 bill and 1 work session. Also, you'll notice that we don't have Ms. Thornton with us today. Instead, we have Ms. Thomas with us today as our policy analyst. So I see everyone turning around to say hi to Ms. Thomas. Again, Ms. Thomas generally works in HHS and Commerce and Labor?
Yes, she is Commerce and Labor.
She is Commerce and Labor.
Judiciary is just part of it.
Yes, we just for the day. This is just for today, so don't get too attached, folks. With that, we will open up with our work session on Assembly Bill 171. And Ms. Thomas, I will have you, if you would take us through that bill, please.
Thank you, Madam Chair. Margie Thomas for the record. Senate Bill 171 revises provisions governing firearms. It was sponsored by Senator Harris, heard on April 6th, and there are no proposed amendments.
Okay, thank you. Members, are there any questions on the bill? Not seeing any questions, I will go ahead and take a motion for a due pass of Assembly Bill 171.
Motion to do pass.
I have a motion from Vice Chair Marzola. Do I have a second?
Second.
A second from Assemblywoman Considine. Members, are there any additional questions or comments? Assemblyman Gray?
Thank you, Madam Chair. I understand what is trying to be done. I mean, we all want to live in a safer society, and we have got so many gun laws on the books now. I would be much more in favor down the road of putting a whole lot more money into getting the illegal guns off the streets and getting them away from the people that don't, that shouldn't have them already, than creating new categories of people that will wind up just being, having guns illegally, and also making new laws to restrict people from having guns. But there is no way that I can support this one this time.
Okay, thank you, Assemblyman. Anyone else? All right, well, with that, all those in favor, please say aye. Aye. Anyone opposed? Okay, and so by show of hands, I have Assemblywoman Hanson, Assemblywoman Gallant, Assemblyman Urick, Assemblyman Gray, and Assemblywoman Hardy. And with that, the motion passes, and I will give that floor statement to Majority Leader Howdigi. Thank you, members. With that, we can go on to our next item, which is Senate Bill 407. This measure revises provisions relating to personal financial administration. It is sponsored and presented by Senator Orenthal and Mr. Alan Frere, who is with us in Las Vegas, I believe, and so as a co-presenter. And so with that, Senator, your hearing is open, and please proceed when you're ready.
Thank you very much, Chair Miller, members of the Assembly Judiciary Committee. It's good to be back here. I was a former vice chair of this committee and served on this committee every session I served in the Assembly, so I have lots of great memories. Yesterday, former Assemblywoman Frances Allen was up here, and we both served on this committee in the 2007 session. We were reminiscing about Pat Hudson, who had been her teacher at Galena High School and worked with me in the legislature. And a lot of good memories on this committee, and hopefully I'll have good memories of today if you're all very nice to me and ask very friendly questions. But Senate Bill 407, for the record, James Orenthal, Senate District 21. I'm presenting Senate Bill 407 today, which is a bill having to do with trusts and estates. Something, most of us don't want to have to think about, but everyone should, and everyone should really consult with an attorney who is skilled in this area. And, you know, as most of you know, I practice as a deputy public defender in juvenile court. And you're probably asking, why am I carrying a bill regarding trusts and estates? I bet James Orenshaw's never written a will or a trust in his legal career. And you're right, I've never written a will or trust in my legal career. I struggled to get a C in trust and estate over at UNLV with Professor Higdon a long time ago. But I've always been very interested in the subject, and I think it's very important. I was lucky enough this session to be asked by the State Bar Trust and Estate section to work on their bill, which is something that has spent about 18 months being vetted, approved by the State Bar Board of Governors, by the Trust and Estate section. A lot of hard work by some of our really finest trust and estate attorneys in the state went into Senate Bill 407. There is an executive summary, which is on Nellis, which I think sums up a lot of the sections. There's also a friendly amendment on Nellis proposed by the Trust and Estate section. With that, Chair, with your indulgence, one of those great minds, one of the great practitioners in trust and estate law here in our state is with us at the Sawyer Building, Mr. Alan Freer. I would ask your indulgence in allowing him to walk us through the bill, and then I'm happy to try to answer any questions and potentially use my lifeline to Mr. Freer if I need it. Thank you.
Absolutely, thank you.
Alan Freer for the record, and appreciate the opportunity, Chair Miller. Pleased to present a bill that's been drafted and sponsored by the Probate and Trust section of the State Bar. Probate is an important aspect of the law. Unfortunately, death touches us all and is most difficult, and it's at this most difficult time when we're most vulnerable. And because of that, we need laws that reflect what our Nevada residents need. We need clear processes and procedures that allow families who are in a period of grief to have a path that is free of unnecessary stress while at the same time appropriate to protect assets and enforce obligations. In addition, tax laws and federal at federal level change regularly alter and evolve with each new tax bill, keeping our laws current in connection with not only state and local issues, but also with a focus on a national level taxation helps our residents plan for the future. Nevada has developed an outstanding status nationally and worldwide as a place for establishing trusts because of how our legislature responds to new issues, maintains laws, and our courts have been very supportive of the legislature's laws that have been passed. This provides stability for our trust and estate residents. A couple issues that have come up as to why probate law is more important these days and maintaining the laws is that residents are very mobile and often have plans not only in this state but in many states, and they move back and forth between states, and this is simply a reality of our times due to the mobility of the Nevada residents. But without clear laws, this can create conflicts in the applicable laws, absent maintaining current laws that address these issues that would otherwise result in more litigation and difficulties. Lastly, rights to privacy to protect against identity theft are all new to the area of probate. Unfortunately, thieves and scammers have become savvy to checking probate court records for potential victims who have inherited money. Absent updates, we find that the current laws require mandatory disclosures of highly sensitive material of not only addresses, names of beneficiaries, but also amounts that they would be receiving. With the advent of open online access to court records, thieves and scammers can gain access to this sensitive information without a lot of effort. But now, because it's all electronically and easily searched and accessed, this puts our seniors, young people, and all of us at risk. With this overview of the importance of probate law in mind, and due to the legislature's vigilant amendments, Nevada does rank as one of the top 3 states in the nation with respect to the rapidly evolving laws and governing trusts and estates. SB 407 was drafted to keep pace with this evolution, to streamline the administrative process, and to ensure that a person's wishes set forth in an estate plan are honored to the greatest extent possible by law. There are 4 general objectives with SB 407. 1, clarify laws relating to trusts and estates. 2, remain current as one of the top 3 leading jurisdictions for trusts and estates. And 3, streamline the probate and trust administration process. And 4, shore up safeguards to prevent abuses. We thank the members of the committee for considering and passing the probate and trust sections bill each session. I'd like to once again thank Vice Chair Marzola for sponsoring last year's trust and estate bill, which was AB 318. With that, I will move into kind of an overview of the various sections of the bill. There are 18 sections. Section 1 amends the jurisdiction and venue statute for estates, which is NRS 136010, to distinguish and clarify between the separate legal requirements of jurisdiction and venue. Sections 2 and 3 of the bill amend the support of family and small estate statutes, NRS 146050 and 146070, to clarify the relevant needs and resources to be considered in establishing a probate homestead. While Section 3 provides a mechanism to more efficiently manage and set aside proceedings, which are generally small estates, by giving the court an additional tool for appointment of a specific person other than the personal representative to execute set-aside documents and deeds and pay bills that are authorized through the court proceeding. The goal of this amendment is to maximize the amount of assets going to the benefits or going to the beneficiaries of a small estate and by minimizing administrative hurdles. Sections 4 and 5 amend the sales, conveyance, and exchange statutes under the probate code to increase efficiency by eliminating unnecessary correspondence with persons who have no interest in the property being sold. At present, an appraisal of real property in a probate proceeding can only be waived by the consent of all beneficiaries or heirs to the estate, even if they would not otherwise receive the property or receive the proceeds of that property. This section's intended to limit the waiver procedure for those interested limit the waiver procedure only to those who are interested in the proceeds of the house or the house itself. This is consistent with the rest of the probate code that only requires notice to interested persons under 132-185. Section 6 is a technology update that amends notice provisions of NRS 155010 to permit electronic service where available in the district courts to streamline administration. Sections 7, 9, and 16 of the bill in turn provide further clarity to declaratory relief statutes. Section 7 amends the declaratory relief statute to make clear that an interested person, as defined in NRS 132-185, may request relief. Likewise, sections 9 and 16 add new chapters in NRS 163 and 164 to define, establish, and reinstate the capacity of a trustee. Section 11 is essentially a tax and trust law clarification to better define a support interest under a trust as providing a mandatory requirement to support a beneficiary, whereas before it was ambiguous and caused potential issues with federal tax law. Section 12 is designed to keep up with the evolving area of trust law regarding trust protectors, which is a relatively new tool in the toolbox for trust planning. This amendment to NRS 163-5553 provides that a trustee may impose or release fiduciary obligations on a trust protector as provided in the instrument, and further sets a default rule that in the absence of specific language, trust protector responsibilities are fiduciary in nature, which imposes a higher standard of care. Section 13 is drafted to streamline the court process and further protect beneficiaries of trusts from having their private information become public. These sections provide a statutory right in favor of those beneficiaries to keep confidential certain information relating to a trust that otherwise would be required to be disclosed as a public record in trust proceedings. Where presently such disclosures are open to public view until a motion to seal is granted by the court, which often, with especially the advent of COVID, we've got down here in Clark County, usually a lag time of approximately 3 to 4 months before a court can hear and enter an order in probate proceedings. These proposals were created, this statute or this section would allow for that information to become confidential at the outset. These proposals were created after canvassing other states' treatments of beneficiaries' private information and provide an adequate middle ground between states that go too far, in my opinion, such as South Dakota, in granting privacy, where they have all trust proceedings automatically sealed for the entire proceeding as opposed to just the confidential information. With this middle ground, and you contrast that with states that have no laws to protect beneficiaries. The district court under this section would still have discretion and final say regarding the privacy of information. It just provides an automatic and temporary confidentiality issue until the issue comes before the court. Section 14 is the most expansive clarification in the bill. It amends NRS 164.010 in light of the constitutional long-arm jurisdiction concerns raised by the Nevada Court of Appeals and Nevada Supreme Court, and clarifies when and how a court assumes jurisdiction and what factors are relevant for determining venue. Section 15 clarifies what information a trustee is required to provide a beneficiary in a notice of irrevocability under NRS 164.021. Sections 16 and 17 are technical corrections to the Uniform Principal and Income Act to fix inadvertently omitted language and expressly provide that a trustee is exonerated from taking action under the Uniform Principal and Income Act, whereas before there was only the negative implication because the express language stated the trustee was exonerated for failing to take action under these statutes. With that, we do have, as Senator Orenshaw noted, a friendly amendment that the section has provided in response to a concern raised by the Press Association, I believe. Presently, subsection 4F of section 13 permits a court discretion to order other documents confidential in a trust proceeding. It's kind of a catch-all provision. The proposed amendment would add an additional requirement on the court to make a finding that the confidentiality of such additional documents outweighs the public interest. And so the way this amendment would set up is there are, in subsections A through E, there's automatically deemed confidential information. Subsection F would give the court further ability to deem information confidential under that statute, but only if it makes that weighing consideration. The probate and trust section appreciated the concerns raised by the Press Association, and that's what engendered the proposed amendment. And with that, I'll turn my time back over to Senator Orenshaw. Thank you.
Thank you, Chair, and I appreciate Mr. Freer walking us through the bill. Happy to answer any questions.
Yes, thank you, Senator, and thank you, Mr. Freer, for your presentation. My first question is in regards to the amendment. So I see on Nellis, there was the amendment that was adopted, Senate Amendment number 425. However, during the presentation, I'm not sure if the intent was to allude to another future amendment that was coming. Mr. Freer?
I might be able to answer that if it's okay, Chair Miller.
Whomever would like to answer, yes, please.
Thank you. James Orenshaw, Senate District 21. There's an amendment. I'm holding a one-page amendment to 407 proposed by the Probate and Trust section. I believe that had been submitted to be on Nellis. If not, I apologize, but I do have copies of that amendment here, and I can walk them over to your committee secretary.
Please do if you have enough copies, because I don't believe we have that, and I don't see it on Nellis. Is that the one on Nellis? Oh, it just appeared on Nellis. That's okay. We have it now. It just appeared right now? So it just appeared, Senator, so.
Thank you very much, Chair, and sorry about that. Thank you.
That's okay. So it just appeared, so members go ahead and take a few minutes to review, and I believe that's the amendments in regards to what Mr. Freer was referring to, correct?
That's correct, Chair. It's Section 13 of Senate Bill 407, and that would be subparagraph 4, line F. After any other information ordered by the court, there is that additional language, comma, where the public interest is outweighed by confidentiality.
Thank you. We have, members do have some questions, so I'd also like to begin with those. Our first question will be from Assemblywoman Summers Armstrong.
Thank you, Madam Chair, and thank you, Senator Ornshaw, for this interesting bill. I'm always concerned about electronic notice. Can you just give an explanation in Section 6 to permit electronic service where available? How are you all confirming the desire for electronic notice on these issues? Because I would think that in many cases, some of the folks who are involved could be seniors or people who might have limited access. So if you can just kind of explain to me how you're determining when to use electronic notice.
Yes, Alan Freer for the record. And if I may direct my comments, Chair Miller, directly to Assemblywoman Summers Armstrong.
Yes, please, go direct.
Okay. So the current process, the court has rules for each judicial district that govern the electronic filing requirements and electronic service of documents. In each of those jurisdictions that I'm aware of, there are provisions for people who do not have electronic means for them to receive documents or to file documents with the assistance and get assistance to have them electronically recorded. The problem that we have is in the statutes themselves, it only talks about notice being sent. It does not make any distinction between electronic notice. And so what we were trying to do with this section is just bring it in line that electronic service that's permissible under the court rules in each of those jurisdictions also serves as good notice for notice provisions such as NRS 155010.
Sure.
Okay, so Mr. Freer, when you're speaking, in your summary, you said to permit electronic service where available. Are you speaking of just of serving the document on someone like a notice, or are you talking about filing? I think that's where I'm a little bit, because in 6B, this is specifically speaking of the Nevada electronic filing and conversion rules, but but in your executive summary, you say service, and I see those things as two different things. Filing a pleading is one thing, but serving someone notice is something else. Or am I just a little bit confused?
Alan Freer for the record. No, you are not confused. There are two separate electronic filings and service provisions under the each judicial district, but the issue on the statutes isn't necessarily filing because that's obviously a judicial function, but we have issues where when you do an electronic filing, you are required to give electronic notice to those people that have been implemented into the system for that particular case. So, for example, when you make an appearance and you file a document electronically, in order to file that document electronically, you're deemed to have consented to electronic service under those rules. But however, even though the courts say you've been deemed to accept service under those rules, we don't really have the corresponding statutes that do that. And so basically when we say where available, that just means in jurisdictions that allow for electronic filing, the service would occur in coordination with that.
Thank you for that. Our next question is from Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. Mr. Freer, I don't have a question about a specific line, but, now that you're revising some of the terms having to do with jurisdiction, how does that mesh with jurisdiction from other states? So is there a possibility of a conflict between states, and how is that addressed when two different states possibly could have jurisdiction?
Alan Freer for the record. That's a good question, Assemblywoman Summers Armstrong. Cohen, sorry. It's one of those, I gotta say, it's a little intimidating being able to talk to you 15 people.
It'd be worse if you were here in the room with us.
That is probably true. So it's a good thing you can't see any beads of sweat that might be coming from my brow. With respect to the jurisdictional issues, this trust and estate proceedings talk about assuming jurisdiction primarily in rem, because we're talking about governing and administering property. And so that's under the Supreme Court doctrine of in rem jurisdiction. There's also a personal jurisdiction component that people that are appearing, that are administering, or that are beneficiaries, that are otherwise interested, the court also has personal jurisdiction over those people. The laws of other states and the typical laws are that once a court assumes in rem jurisdiction, it's assumed jurisdiction to the exclusion of any other state, and that's a U.S. Supreme Court policy. What our laws that we're presently changing, we don't necessarily currently we already have in place that upon assuming in rem jurisdiction, Nevada now is the place of jurisdiction for all aspects of that property. We also currently have on place a statute that says that is retroactive to the time of filing as opposed to the court order. And that was done several sessions ago to prevent increasingly races to the courthouse between jurisdictions. The Nevada Supreme Court, I can't remember if it was the Nevada Supreme Court or Court of Appeals, recently in the Song decision, it was the Nevada Court of Appeals in the Song decision, recently upheld that statute that provided for retroactive effect. So in essence, there is some varying degree of laws between states with respect to assuming jurisdiction, but the changes we have made clarify the jurisdictional stuff, because before there was some muddying of jurisdiction and venue, but they are consistent with what the Supreme Court has upheld. Our Nevada Supreme Court has upheld, and they're consistent with the U.S. Supreme Court findings on in rem jurisdiction.
All right, thank you for that. Not seeing any additional questions, I will go ahead and open it up for testimony in support of Senate Bill 407. If there's anyone here in Carson City that would like to come testify in support of Senate Bill 407? Is there anyone in Las Vegas? Not seeing anyone? Broadcasting, will you open the lines?
There are no callers at this time.
Thank you. Is there anyone here in Carson City that would like to testify in opposition to Senate Bill 407? Not seeing anyone. Is there anyone in Las Vegas? Broadcasting, will you open the lines, please?
There are no callers at this time.
Thank you. Then I will open it up for anyone wishing to testify in neutral. Not seeing anyone. Is there anyone there in Las Vegas? Also not seeing anyone. Broadcasting, will you open the lines?
There are no callers at this time.
Thank you. Senator, would you like to come make any final remarks?
Chair Miller, members of the committee, James Orange, House Senate 21. As you'll notice, there's no beads of sweat on me today. Thank you for Mr. Freer having to handle all the tough questions. I think our UNLV professor, Michael Higdon, would be proud seeing me present a probate and trust bill with one of the greats like Mr. Freer. Thank the committee for their time. I believe the bill will help our constituents, especially when they've lost a loved one, and trying to sort out the probate issues with the trust and the wills. I hope the committee will consider moving forward with it. Thank you.
Thank you so much for the presentation and for the bill. With that, I will go ahead and close the hearing on SB 407. Our last item today will be public comment. So everyone who chooses will have up to 2 minutes to make comment about anything other than the bill that's under the purview of this committee. So is there anyone here in Carson City that would like to make public comment? Anyone there in Las Vegas? Not seeing anyone broadcasting. Will you open the lines, please?
The public line is open and working, but there are no callers at this time.
Okay, thank you so much. And with that, we will go ahead and close public comment. And I'm trying to remember what time we're on the agenda for on Monday. Good thing I'm in, is it 9 o'clock? Oh, no, wait, am I? Like, I should know better than that. Gray's like 10:30 a.m. Let me check. We may be on for 9 a.m. Let's just go back here and check quickly. It is 9? Okay, 9 a.m. on Monday morning. See you all then. Have a great weekend. This meeting is adjourned.